Hello, my name is Debbie Bazarski. My pronouns are she, her, hers, and they, them, theirs. And I am the director of the LGBTQI+ Center for Faculty and Staff. I'd like to say welcome to Evaluating 303 Creative, Implications for LGBTQI+ Equality and First Amendment Challenges to Anti-Discrimination Laws. We're excited to have you here with us today. This has been a wonderful collaboration with the BU School of Law, who we would like to thank. I'd like to take a moment to particularly thank Linda McClain, Joanne Thomas, and Elizabeth Clancy from the School of Law for all of their great work in putting this event together, and also Allison Riley, who's the Assistant Director of the LGBTQI+ Center for Faculty and Staff. Thank you all. We are looking forward to today's program about 303 Creative LLC versus Alanis and what the Supreme Court decision means for LGBTQI+ rights and the protections afforded more broadly by non-discrimination laws, as well as the implications for defining goods and services offered in the marketplace as creative expression and speech protected by the First Amendment. Now I'd like to introduce today's moderator, Victoria Shannon Sahani, whose pronouns are she, her, hers. Victoria is the Associate Provost of Community and Inclusion and Professor of Law here at BU. Victoria, thank you for moderating today's panel, and I will gladly turn things over to you.
Thank you so much, Debbie, and I really appreciate the work of you and your team on this outstanding event. I also want to say welcome on behalf of the law school as well, and we're so pleased to have you with us for this exciting and very timely discussion. I'd like to introduce our speakers, and you can certainly look their bios up on the internet, so I won't go through their full bios, but I'll just give their names, their pronouns, and their titles. So we have Sean J. Kealy. His pronouns are he, him, his. He's the Clinical Associate Professor of Law at the law school. I have Linda McClain, pronouns she, her, hers. Robert Kent, Professor of Law at the law school. Robert Tsai, pronouns he, him, his, Professor of Law and Law Alumni Scholar at the law school. And Michael Ulrich, pronouns he, him, his, Assistant Professor of Health Law, Ethics, and Human Rights at the School of Public Health and the law school. Thank you all so much for joining us. We really appreciate your expertise and your candor during this event. So the format for this event will be that we will have about an hour of discussion with a question that will be addressed first to one panelist, and then other panelists can jump in and answer the question. And then around the 1 hour mark, we will have a Q&A session. So please, as was mentioned at the beginning of the event, enter your questions in the Q&A box, and our team will be sure to feed those questions through for our discussion at the end. So be ready with your questions, and you can start feeding them through at any point, and we'll answer them at the end. So let's begin our discussion, and I want to start with Linda. Linda, could you please briefly put the 303 Creative case in context of the case law history? What is this controversy about, and how does this case echo prior controversies?
Thanks, Victoria, and thanks for facilitating the discussion today. So 303 Creative, the court granted cert on the following question: whether applying a public accommodations law to compel an artist to speak or stay silent violates the free speech clause of the First Amendment. And that's a kind of loaded way to frame the question, but Justice Gorsuch answered in the affirmative that indeed Colorado's anti-discrimination law was compelling website designer Lori Smith both to speak language she didn't want to speak and to stay silent and not say things she wished to say. And in his opinion, he repeatedly quoted a 1943 opinion about a compulsory flag salute, West Virginia Board of Education versus Barnett. And he says, by allowing all views to flourish, the framers understood, we may test and improve our own thinking, both as individuals and as a nation. For all these reasons, quote, if there is any fixed star in our constitutional constellation, close quote, quoting the Barnett case, it is the principle that the government may not interfere with, quote, an uninhibited marketplace of ideas, close quote. And here he's citing a Massachusetts case that reached the Supreme Court about a buffer zone for abortion clinics, McCullen versus Coakley. So what I'd like to talk about in terms of setting the stage is 303 Creative basically addressed a question the court considered but didn't decide in Masterpiece Cake Shop. Jack Phillips, another Colorado business owner, you may recall, he could not, he said, make wedding cakes for same-sex marriages because it violated his conscientious religious beliefs. He also said it would compel his speech, contrary to Barnett. Justice Kennedy ruled in his favor on a claim that the civil rights commissioners had been hostile toward his religious beliefs in the way they treated his case, but they didn't reach the merits to say that Colorado had to give him a religious exemption, which is what he sought. They also didn't reach the speech claim, although Justice Thomas would have reached it, citing Barnett, and would have reached it in Jack Phillips' favor. So in a sense, 303 several years later, in another case brought by the Christian conservative litigation group, the Alliance Defending Freedom, now the court had another chance with a very different composition of the court, a 6-3 conservative court ruled in Lorie Smith's favor. And you may have read about Lorie Smith, but basically she was a website designer who had never designed wedding websites, but she wanted to expand her business to do so. But she wanted to post on her website a statement explaining that she feels called by God to do website design to explain, quote, his true story about marriage as a lifelong union between one man and one woman, close quote, and that her convictions about marriage prevented her from creating websites promoting and celebrating ideas or messages violating her beliefs, such as websites for same-sex marriage or any other marriage not between one man and one woman. Now, Colorado, like many states, has an anti-discrimination law, and like Massachusetts and about 20 other states, it also includes protection against discrimination on the basis of sexual orientation. And so even before she offered these sites, she brought a pre-enforcement challenge to this law, wanting to get a declaratory judgment that if you apply this law to her to prohibit her from doing these things, it would be unconstitutional, right? And she lost in the 10th Circuit. However, the 10th Circuit did rule that her website design was pure speech, right? Not simply conduct that had some expressive element. And because it was pure speech, it required a strict scrutiny test, which law students will know means that you're supposed to have a compelling governmental interest, and there's no less restrictive alternative to the measures you adopt. And so, not to get into all the weeds on this, but basically, the court found that while Colorado couldn't satisfy the narrowly tailored rule with respect to the dignitary interest people have in anti-discrimination laws, it could satisfy it with respect to the important public policy of having goods and services be available without discrimination. So she lost in Colorado in the 10th Circuit, but with some fairly strong language about pure speech. There was a very lengthy dissent, which quoted Barnett 13 times to say that Lorie Smith was just like the Jehovah's Witnesses in the Barnett case in being compelled by Colorado to adhere to an orthodoxy that was contrary to her beliefs. Justice Timkovich even cited George Orwell to say if liberty means anything, it means the freedom to say what people don't want to hear. And Justice Gorsuch, in his majority opinion in 303, quotes that same passage from Orwell, cited by Justice Timkovich. And so looking at the Supreme Court opinion briefly, Justice Gorsuch's 6-3 majority opinion situates Lorie Smith's claims in a long tradition of unpopular or offensive speech that the government is trying to stamp out or prevent, right? And so not only is she like the school children who West Virginia tried to compel to salute the flag, to solidify national unity in times of war, but she's also like the people who organized the St. Patrick's Day parade in Massachusetts, who a court said had to allow a lesbian, gay, bisexual group to march with them, even though they didn't want to embrace that group's message. And she's like a long line of people with unpopular or even offensive ideas who the government's trying to silence or not allowed to speak how they want to speak. So that's how Justice Gorsuch viewed this case. And what's interesting or troubling or whatever you want to say about it is he basically conflates the commercial marketplace of goods and services, where states like Colorado are trying to ensure people can get goods and services without discrimination, to a marketplace of ideas, to a place of public discourse, so that Lori Smith's message about marriage can take the form of refusing certain clients, right? And she can advertise her intent to refuse. So where Justice Gorsuch situates Lori Smith in a long line of people who require a courageous Supreme Court to stand up to the state and the government through the First Amendment, Justice Sotomayor, in her dissent, situates the case in a long line. She situates the case as departing from a long line of Supreme Court cases courageously standing up to challenges to landmark civil rights laws, preventing discrimination based on race in the case of Title II of 1964 Civil Rights Act, sex in the case of many state laws, where the court stood up to constitutional challenges and affirmed the legitimacy of civil rights laws and the government's compelling interest in such laws. And she says until today, the court stood up to these challenges and affirmed the state's powerful interest in anti-discrimination law and individuals' interest in obtaining goods and services in the marketplace without discrimination. And so you can think about the majority and dissenting opinions as having different narratives and different emphases. Justice Gorsuch stresses the plight of the business owner like Lori Smith, who has views that aren't popular in an era in which, due to Obergefell versus Hodges, same-sex marriage is a constitutional right across the country, right? And so people who oppose that and don't want to facilitate same-sex marriage in any way, he believes are akin to dissenters, who have an important message to communicate and that must be protected. Justice Sotomayor has many narratives, in her opinion, about the harms people suffer when they're denied goods and services based on disability, based on race, based on sexual orientation, based on other qualities or characteristics, and how the majority's opinion really threatens important civil rights protections. Now, Justice Gorsuch, I'm on my last minute, Justice Gorsuch says, sure, there may be difficult cases that will arise in the future, but he kind of waves his hand at Justice Sotomayor's many examples of whether the court's protection of expressive conduct in the marketplace would allow certain forms of discrimination. He calls them a sea of hypotheticals that we really don't have to consider because we're dealing with a case here on stipulated facts that involves pure speech. So I think I'm at 10 minutes and I'll stop. Thank you so much.
Thank you so much, Linda. That was a tour de force of the details and nuances of both the majority and the dissent. So I really appreciate that. I want to invite other panelists, if you have any comments you want to add briefly on the background of the case and how we think about this case in its historical context. Robert.
Yeah, I just wanted to pick up on something that Professor McClain said about the how this case fits with or either comfortably or perhaps less comfortably among the other compelled speech cases. Of course, Justice Gorsuch presents this case as if it's a sort of seamless application of sort of older principles. But, in fact, you sort of have to read the dissent to see that this idea that the state is not permitted to compel someone to say something that they don't want to say. A couple things. One, the notion has been expanded over time, and then two, the court has increasingly been mushing together very different fact patterns to the point where it's incredibly unclear what the purpose of the doctrine really is. Professor McClain mentioned the Barnett case. There it seems pretty easy for us to sort of sense what really is at stake. You've got school-aged children and their parents who are devout believers. But the key there is that being forced to salute the American flag puts their soul at risk pretty clearly, and also exposes them to social ostracism among their own fellow believers. And doing so is a clear violation of their doctrine. The other case involving Hurley, which was whether a St. Patrick's Day parade, if they were forced through the application or enforcement of public accommodation laws to accept gay rights activists to present a gay rights message, we might disagree about whether the court appropriately drew the line there, but at least we understand what is at stake. They pointed out that doing so on those facts would have contradicted or undermined the central message of the parade. By contrast, we have a very different kind of scenario here, right? We have a business owner who, you look at the website even today, she does not hold herself out on her website, even her business, as if her whole business is a sort of biblically grounded enterprise from everything she makes and everything she sells. And so even from that perspective, it's hard to see, how much religion is central to the things she makes and sells and the message she holds out to the world, unlike the other sort of scenarios. Questions, right? Does the business owner hold herself out? It doesn't seem like the answer is yes, unlike the other scenarios where there might be a risk of confusion as well. Would anyone even know that her role in designing a website for a same-sex couple, right, necessarily means that she herself supports the notion of same-sex marriage? Unlike the other scenarios, it doesn't seem like the average viewer or participant in the marketplace would necessarily jump to that conclusion. People of different beliefs sell lots of different products, and we don't always jump to the conclusion, right, that we endorse every usage of the product and so on and so forth. So we do have a real extension in some ways of these kinds of cases. And here's what I would just end with. Is that the risk is that if this area of law is unclear, what it becomes is no longer about a kind of limited protection from like the most severe kind of compulsion, where one's message, expressive association really is at stake, and becomes something like a political opposition or a kind of vague conscience-based objection to the existence of any law, much less an equality-based law. And there we are on a real slippery slope if that's where we're headed.
Thank you so much, Robert. And you really raised some excellent points about how this case could potentially have impacts for broader areas of law with respect to how we think about the slippery slopes, the rights of business owners who are providing ostensibly non-religious services and yet claiming there's a religious perspective that they're trying to convey through their services. And so what you've done here is really teed up my second question very well. So thank you so much, Robert. Could you explain a little bit more? I'll just press a little bit more here on these competing narratives and interests that this case involves, including things like conceptions of community, federalism, politics, and whose rights should be protected.
Sure, happy to tackle that one and get us going on this. So again, this sort of picks up on something Professor McClain had set out in her presentation, which is she said that there's sort of very different conceptions of what's going on, different narratives. We really have to read both the majority opinion alongside the Justice Sotomayor's dissenting opinion to really get a full picture here, because for the majority, Justice Gorsuch's opinion is a fairly atomistic picture that he paints. It's really very narrow conflict between a Christian businesswoman in an oppressive state, right, who is forcing her to violate her deepest beliefs, to say something that she doesn't want to say, by having to make this website, and then even to be forced to take on remedial training, right, if she is found to violate public accommodation laws. There's no context of the political, even though the rest of us know in our hearts that the Supreme Court is at the center of big social movements, political movements that have been fighting these questions about the role of religion in public life for decades. And so if you look at Justice Sotomayor's dissent, that's where you really start to get a sense that there has been a political mobilization of the law and of judges for quite a long time. And they have been pushing teeing cases up so that the court might someday expand religious exercise and expand these compelled speech cases in precisely this direction. So Justice Sotomayor's dissent, and here I'm quoting, mentions that there's been a long backlash to the movement for liberty and equality for gender and sexual minorities. And I think this is right. Part of the backlash is that you see the rise of public interest organizations like the Alliance Defending Freedom, who were active in not only this case, but in the Dobbs case, in another case that I can think of where they represented Christian adoption agencies that want to discriminate against Jewish parents, for example. And if you look at ADF's website, for example, you'll see that they now talk about religious freedom and the sanctity of life as things that they support, but they very clearly in older presentations of the organization say that, and to donors, they're trying to bring natural law back into how the Constitution is understood and enforced. So now, knowing that, does that alter the way or where we think the line ought to be drawn? I mean, not necessarily, but it is important to understand that groups like ADF are part of big movements, and they have a view of what communal life looks like and what rights are most important to that community, and that there are competing conceptions of community life and rights and obligations. And so, on their view, these rights of the business owner, or whether it's the cake shop designer, or here the website maker, or I would submit a larger group of objectors, those rights are paramount, speech and religion, and they don't have an obligation in the same way to treat people equally, even if that has been required of them in positive law. They don't believe that they should have to shed their rights when they enter the marketplace. What are some of the costs of that? We kind of sense it, which is that the replacement costs for getting a cake or getting other necessary goods, a website, other things go up. Probably some more confusion among people who are in this position in terms of who can they buy from, and where they're going to get their necessary materials from. A sense of dignitary loss has already been mentioned. So that's not the only vision of community, right? We can think of another one where the notion of obligation is at least as strong and important as these individual rights to object, right? That if you step into the marketplace, you really should be able to, as much as possible, offer your goods and services to all comers, regardless of your own conscience-based objections, unless they really interfere in a core sort of way or confuse people about what your values really are.
Thank you so much, Robert, and really appreciate how you've laid out these competing ideas, ideologies, as well as interests, and how there's sort of this balancing act that the courts are trying to do. Whether they're succeeding is another question, between businesses and customers, rights of those who are marginalized, rights of those who have certain religious beliefs. So I really appreciate you laying that out. I wanted to also bring in some other panelists. So I see Michael, you have your hand up. Please go ahead.
Yeah, I just want to, talk about this idea of the framing and sort of trying to find this balance and really sort of offer that this case actually is not doing that, right? So if we think about this as the follow-up to Masterpiece Cake Shop, I mean, whatever we might think about the opinion, Kennedy, in the majority opinion, is at least wrestling with there are gay people and they're good people and they deserve to not be, ostracized and stigmatized. But they're also religious people and they're good people and they deserve to, have their beliefs respected. And we're not sure what to do. So we'll just latch on to this one little thing that happened, or one comment. Here, what the court is doing is by framing it as Robert mentioned, is there's no discussion, right, in the majority opinion, really, about the community and the people that will be harmed, or at the very least, the community and the people that Colorado is trying to protect, right? So it makes it so that the court is framing it as Robert said, this is oppressive government interfering with this poor woman's rights and her beliefs and trying to force something upon her, as opposed to wrestling with this competing people, right? They both have rights. They're in conflict here. What is going, how do we resolve this, right? And Masterpiece showed that they didn't really know how to, right? But in an earlier case, it said, well, the way that we should be thinking about this is it really about religion, right? Or does it apply to everybody? It's about something completely different. And it just so happens to interfere to some extent with your religious practice, not even your beliefs, right? But your practice. Right. And that was Justice Scalia in Employment Division v. Smith. Right. And so I think here what the court is doing is saying we don't want to balance. We don't want to. And, the problem that creates is inherently then the court is going to have to pick whose rights, whose harm, who are we going to be focused on here? And by doing that, you are inevitably saying, we're not worried about the other side, right? And there are real implications beyond just any specific outcome to that sort of approach.
Thanks, Michael. It's almost like the court's creating kind of a zero-sum game instead of a balance. It's, someone's got to win and the other person's other side's got to just deal with it. Sean?
Yeah, and just building on what Michael was saying is that one of the things that Justice Sotomayor did really well, I thought, was to go over the history of public accommodations and the rationales for public accommodations and the need to have everyone in society feel as though they're part of the society and not being excluded, not because they couldn't get the services down the road, but because of how that made them feel as a member of the community. And so I think part of what we're seeing here is that ADF chose to have this religious angle because they know that's the key for this court, that when it comes to religious arguments, they're going to side with the people with the religious beliefs over anybody else in society. And it just kind of highlights how this court is getting played by some of the actors out there.
Yeah, there's a question, is the hierarchy changing in terms of which rights are most important? I mean, even in that freedom of speech First Amendment, the rights are in a certain order, and the question is that order getting shifted around a bit with the Supreme Court jurisprudence? A great point. Linda?
I just wanted to say that it's very important to notice that Justice Gorsuch talks about creative expression or expressing ideas of political or moral or social or religious importance. So we've been talking a lot about the fact that Lori Smith's reasons for refusing service were religious in nature, but the opinion's language, because it comes out of this free speech, protect conscience, protect freedom to speak your mind and not have to say what's not in your mind, is broad enough that a merchant could have a political objection to serving a particular customer, or a moral objection that's not rooted in religion. I think the reason that 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 the court that the reason the Alliance Defending Freedom was pushing the speech claim here is the court isn't ready yet, apparently, to overrule Smith, right, which different people talked about, which kind of took down a notch the level of protection of religious liberty, even though religious liberty has been incredibly successful at the court, especially conservative religious liberty claims. But in the meantime, we have a more absolutist First Amendment when it comes to speech, and to kind of take these, as Robert was saying, to take these ideas from First Amendment jurisprudence that government can't stamp out speech just because it's offensive to some, or government can't prohibit flag burning because some people are deeply offended by that, to take that and transplant it into anti-discrimination law, is really has very far-reaching implications. And also, I don't know what people think about this, but a lot of these First Amendment cases, the rationale is that we need an uninhibited marketplace of ideas to support the discovery of truth. It's like the notion that free speech furthers the discovery of truth. It's a little hard to see how that applies in website design, frankly, but that's what Gorsuch is quoting from, that uninhibited marketplace ideas. If you take the rest of the quote, it's to facilitate the discovery of truth. These come out of cases about access to radio bans, back when, the licenses to radio, or it comes out to whether you can picket on the sidewalks. And so to take all those cases, as Robert suggests, and sort of mush them together with a case like this really has a lot of implications. Thanks.
Yeah, thanks, Linda. And you're absolutely right. The court is sort of weaving together a bunch of disparate threads and almost fashioning a new doctrine, or even a new area of doctrine, and doing that on essentially hypothetical facts, which is also pretty stunning here. And so I want to bring Sean into the conversation, talking about the unusual procedural posture, the unusual facts of this case. So can you talk a little bit about the constitutional and procedural implications? And then related to that, I know that you've done a recent informal survey of judicial committee chairs. So if you could tell us a little bit about that too, that would be wonderful. Thanks, Sean.
Yeah, sure. The interesting thing about this case is just how it got to the Supreme Court, and it's something that's almost becoming a controversy unto itself out there. At the heart of this is that here you had a woman who claimed to be a creative, somebody who was going to be expressing herself through websites. Anybody who's seen her website would probably dispute that. I'm not sure how creative it actually is. And quite frankly, I'm not sure how robust the business is. If you look at some of the testimonials on her website and you try and find the website she created for them, they're pretty hard to find. So, I mean, who she was and how she was operating is in question to begin with. But the idea that she could say that I'm thinking of getting into this new business, and there's this well-established public accommodation statute on the books for Colorado, and I'm really worried that Colorado is going to come after me if I do something like this. And to have that get all the way to the Supreme Court, it's not unheard of. I mean, pre-enforcement review of constitutional issues is something that exists. On the other hand, as recently as 2021 in Whole Women's Health versus Jackson, the court said, there's no unqualified right to have something reviewed by the Supreme Court. And in fact, within the Constitution itself, there should be a case or controversy at the heart of the case before the Supreme Court can see it. And there's good reasons for that. There's a need to have an actual dispute taking place so that the court can evaluate it and make its decision as to whether or not or how the law will apply to it. And here, she's claiming a chilling effect for her constitutional rights to speak, and based upon the idea that even before she put herself out there as a wedding site designer, she was contacted by a fellow named Stuart who wanted to get married to another fellow named Mike, and that they wanted her to design all aspects of their wedding, including a website. It turns out And this information was presented to the district court, and I'm sure it was part of the record going to the appellate court as well. It turns out it was all fake. It turns out that there was no Stewart, that when he was contacted, he said, no, I'm married to a woman with a child, and we're, this is not me. But it was presented to the courts as a case in controversy. And so the fact that it got up to the Supreme Court and they're making really a fraud perpetrated on the court, that there was a legitimate case or controversy out there, should give the court pause to say, what are we doing here? Should we be looking at these issues a little more closely before we get involved with, striking down the application of public accommodation statutes, which exist in all but 5 states. And beyond that, you now have a controversy where, the conservative supporters of this decision are saying, well, everybody stipulated to everything and there was no real controversy. And in fact, it isn't even mentioned by the dissent, which makes it even a little more frightening, the fact that it was able to get to that level without a real discussion as to whether the standing should have had been established and the case should have even been there. And it's related to that because it wasn't a case or controversy, I think it just ends up being poor decisional law. What exactly is the meaning of this case? How will Justice Gorsuch's decision be applied? I know I was doing a quick review of how various media outlets were looking at this, and the National Review said it was a simple and straightforward decision. It should be easy to apply. In a moment, I'll give you an example where it isn't so simple and straightforward. That Justice Gorsuch's decision really leaves open a lot of room. As Linda was saying, not just religious objections, but it could be political objections. It could be all kinds of objections as to why I will or won't serve this class of people. And unfortunately, when Justice Gorsuch was making his standard, if that's what you can call it, he was using, artistic examples that what is it that is not going to be allowed under the public accommodation statutes, or what will be allowed? Well, if you're an artist. And then he brings in an example of a speechwriter as well. I've been a speechwriter for various people and never really considered myself an artist of any way, shape, or form. But it leads to, what is an artist? Who is that creative that will be protected now under this case that otherwise would have had to serve everyone if they hold themselves out as open to the public for business? It becomes really interesting when you think about both whether this is going to be over-inclusive or under-inclusive. Will over-inclusive in that, will anybody who claims to be an artist now be able to refuse service? Some chefs see themselves as an artist. Some bartenders see themselves as an artist. And under-inclusive because there are places where there's expressive content that might be out there where I wonder if his standard will include them. And one of them that I was thinking about, Colorado exempts religious organizations from their public accommodation statute. Clearly understanding that certain religions, as Robert was saying, it goes to the core of your belief. You don't have to serve people who aren't believing in that core. But on the other hand, if you had a religious book publisher, not related to any religion, but rather, a line of books that definitely promote evangelical Christianity, say, or Catholicism. Do they have to publish a book because they're not really artists? I suppose they are being expressive. But where is the line? Where is the court going to finally, clarify who will and won't be caught up in this case? Part of what I was asked to do was kind of talk about the implications for state legislatures and how they're going to respond to this case. So I very quickly, well, it took a little bit of time, but what I decided to do was to survey the Judiciary Committee chairs for the 20 legislatures that tend to be the most LGBT friendly. And so I sent out emails just asking them what they, if anything, they were seeing being filed for bills or potential changes to the law as a result of this case. And it was, as expected, they came back and almost uniformly said, we have no idea. No bills have actually been filed that I have been able to find. And in fact, the senator who runs the committee in Delaware said, I'd love to know what other states are doing if you can tell me. So they're searching for answers themselves. And I'm thinking that they really don't have a direction as of yet, as far as what needs to happen as far as changing the public accommodation statutes. But I was able to find one reaction from Nevada. The Nevada Attorney General is the one who litigates these cases, enforcing the public accommodation statute. And they put out a fairly short, piece of advice. I would say it's only about a page long, but far from the National Review's point of view that it was a simple and straightforward decision. The Attorney General says, though the full implications of this decision are still not fully understood, it's important the public understand what the decision means. And the Supreme Court's decision not to invalidate any specific provision of the state's public accommodation law, though it will disallow certain applications of the law. And so what will it disallow? Nevada can compel a bar to serve a member of the LGBTQ community. It cannot compel a movie director to create a pro-LGBTQ plus rights film. So that's about all they've gotten out of it. And they state clearly that they anticipate a lot more litigation and that they are waiting to see how else they should be enforcing the public accommodation statute. So there's a lot of confusion out there, and the response really isn't clear as of yet.
Thanks so much, Sean. More confusion, and hopefully we'll get some clarity eventually. Robert?
I just wanted to pick up on something that Sean said toward the beginning of his comments. And Sean drew attention to a part of Gorsuch's opinion. I think maybe this is something that certainly got picked up in the media reports of the case. And it might even have a kind of surface appeal to it, which is, let's call it the labor mixing theory for why the court should be protective of Lori Smith's website designing, right? I think it affects a number of us when, someone says, the state is like basically coercing your creative labor, against your wishes. And there's a little bit of this, of course, in the previous case, the Masterpiece Cake Shop thing about coercing creative labor. But I want to suggest, and I'm going to be very critical here about Gorsuch's opinion, that this should be a non sequitur. Whether labor is involved is really not the key thing under the original sort of thrust of the core speech case. It's not really the amount of creativity or labor that's involved. It's whether somebody has a kind of coherent message to the rest of society, and whether they're then being forced to say something that interferes with that. And I can imagine a set of facts where the labor is involved, and let's say she were advertising herself as a religiously She only does religiously inspired artwork on her websites, on everything she sells has a religious theme. She's a religious artist, and therefore to be forced to make a kind of website and put that out in the world that others would take as a inconsistent with her message to the world. Yeah, to me, that's a true example that's closest to the sort of core speech. But here it's really unclear whether she even has a coherent message to the world, and what it is exactly that the mere designing of a website for this couple is telling the rest of the world, other than they need a website, to get people to buy things for their wedding and as gifts and so forth. And so, all that's left then is that there's some labor involved, and she objects to her labor being coerced to making something she doesn't want to make. But a lot of us have to sell things and buy, make things when we might not want to. But that's part of being in the market.
It's a great point, Robert. And this question of, commerce, the idea of commerce being speech is a relatively new or relatively recent, I think flag that the Supreme Court has been flying in a variety of contexts. And in this case in particular, it's not that she's got some active business going on, and then she's been asked to serve a true LGBTQI plus client. It's this whole hypothetical, I might want to do this business. I mean, this is just, it's quite unusual, I think, for the court to articulate a standard or try to articulate a standard in this context, especially. And I think you're absolutely right. The question of this expression, the question of, is it art really, that Sean brought up earlier and that you also echoed are crucial. Linda?
I just wanted to say a couple quick follow-ups on what Robert said. There was a wonderful friend of the court brief filed by public accommodation scholars, and they tried to explain the narrow circumstances in which a government law could actually be impermissibly burdening speech rather than regulating conduct in which speech is a part of it. And they pointed to, and one of these prongs was that the person is kind of expressing a clear message that's going to be interfered with. And they pointed out the fact that Laurie Smith had done websites for a wide-ranging number of clients, including a law firm that specializes in divorce. Now, if you really adhere to a biblical view of marriage, would you really be doing website design for a divorce firm? I mean, depending on your denomination. And I think she'd even done some work for a group that, I don't want to get this wrong, but maybe was in favor of legalizing marijuana. I mean, she had all sorts of clients, and it was very hard to find one clear Christian message or whatever out of it. The other thing I want to mention is that, this notion of what's artistry, one of the really interesting arguments made in the arguments in the friend of the court briefs in Masterpiece Cake Shop was one of the important civil rights precedents where a business owner didn't want to serve Black customers and raised various constitutional objections, was this case involving Ollie's Barbecue. And people pointed out that barbecue is regarded as an art form. And you could say barbecue is expressive, So anyway, I mean, there's been a long history of various types of constitutional objections to civil rights laws, including, believe it or not, involuntary servitude. There was this whole strand of ideas that compelling a white barber to cut Black hair, was a form of forced servitude, and any kind of forced association as well, like that you were compelling association. So there's and Justice Sotomayor very effectively even showed how in one of these cases involving racial segregation, one of the parties cited to Barnett, so there's a long history of these various objections that you're imposing an orthodoxy on me, you're imposing a government orthodoxy on me. So one thing I worry is this expansiveness that I think one of the panel said earlier, anything government does is imposing an orthodoxy. And just recently, Justice Thomas dissented from a challenge to Washington State's ban on conversion therapy. The court didn't grant cert to the licensed family therapist who challenged Washington's law, but Justice Thomas would have granted cert, and he cites Barnett to say that Washington is imposing an orthodoxy about gender and sexuality. And this therapist is kind of being shut down because he doesn't adhere to the state orthodoxy.
Thanks, Linda. Yeah, the idea that the state decides orthodoxy and that it's extreme individualism, almost every single idea that a person has should not be imposed at all, even the littlest bit on the state. Question is, what happens to society in that context, right? I'd like to bring Sean in, and then we'll pull Michael in for our final question. Go ahead, Sean. You're on mute, Sean.
Real briefly, to build on something Robert said, you know, I can see one of the things that states may want to do is to carve out some clearly expressive behavior that won't be subject to the public accommodations law. But where to draw that line is so very difficult. And I don't think it's going to be artistic. What I was thinking about was a friend of mine who's a lobbyist. And so they engage in political speech, and they, you know, certainly not artistic to be a lobbyist, but on the other hand, you know, should that person be forced to represent clients that they don't necessarily agree with, or that doesn't fit in with their customer profile? You know, I can see that where your speech is so intertwined with the speech of the client that it's almost impossible to distinguish between the two. But I think, you know, the notion that it was going to be an artistic endeavor is what's going to be excluded. I'm not sure that that really fits or is workable.
Yeah, that's a great point in your example. The speech is literally speech on behalf of the client, and that's about as close as we can get to the speech being intertwined. I think that's a great point. I want to bring Michael in here, and this has been a theme sort of throughout the panel. We brought in these broader implications about the line of cases where this case 303 Creative is one of many, sort of setting up a culture shift. And I wanted to bring Michael in here to talk about that sort of broader context. Michael, could you tell us a little bit about your research on gender affirming care and what's happening with anti-trans laws and the involvement of courts and politicians in medical practice?
Yeah, thanks. So, you know, as you know, has been discussed, part of the issue with this case is how did it get to the court? Why did the court take it? And sort of how the court is accepting the framing of the issue. And, you know, one of the things that I'm really worried about with the gender affirming care bans is, should the Supreme Court end up taking this, and there's a cert right now from the ACLU asking them to review these bans, it is, you know, how are they going to think about and frame this case, right? Because if they take it as the state is trying to protect minors from experimental medical procedures with permanent, long-term, irreversible damage, well, that looks a lot different than framing it as you have a marginalized, underserved minority population that suffers 2.5 to 3 times the rates of suicidal ideation, suicide attempts, and completed suicide than their peers, while suicide is already the second leading cause of death for youth. And that in some surveys, right, transgender youth have said that the secondary option to gender affirming care is suicide, right? That they see that as the backup option, right? And so that in that framing, right, you think, well, the state is banning medical care's availability, right? Because the availability of gender affirming care does not mean that it will be applied or used in every and all instances, right? There are still ethical guidelines for medical practice. There are still medical malpractice and tort laws, right, for anybody that acts inappropriately in terms of their clinical work, right? Well, then that case looks a lot different, right? Because what's the impetus behind why the state is passing this law, right? And so recently in some of the lower court cases, there's been, they've had some, some questionable, I would say, or relatively new, newly formed medical groups, right, to create this illusion of medical uncertainty, because all of these sort of long-standing medical organizations support the availability of gender-affirming care, right? But most people aren't going to know, for example, the difference between the American Academy of Pediatricians versus the American College of Pediatricians, though the American College of Pediatricians was formed in 2002 to oppose same-sex marriage, right? And so these sort of things, again, that creates the illusion of medical uncertainty. Well, then the court says, the issue here is, can a legislature, enact a law in a place of uncertainty? That's not our role, that's their role, right? Separation of powers. And so I think this is really important. And again, beyond even sort of the LGBTQ plus and trans space, right? If you look at the mifepristone lawsuit, right? The Alliance for Hippocratic Medicine was formed the day after Dobbs. It just so happened to be formed in Amarillo, Texas, where there's only one judge, Merrick, who's definitely going to hear the case when they bring it. Those sort of things have a really, really significant role in before you even get to the outcome, right? You are creating an easier path to a specific outcome. And the court seems completely willing to do this. And so when we think about gender affirming care bans, right, no state even proposed something like that before 2020, I think. Even though it's been around for decades, right? And research on trans individuals has been around for even longer. And so why and where did this come about? And and frankly, there's honest quotes from people who have worked on this to say, after Obergefell, we needed something to galvanize conservative public in terms of getting them to donate, getting them to work on and be motivated. And we did some polling, and this was something that stood out, right? Because if you remember, in 2016, North Carolina tried to pass a bathroom restriction on transgender. And there was a huge backlash from companies, professional sports organizations, and that didn't go well. So they went back and did polling. And so, thanks to Terry Schilling, the president of the American Principles Project, who's been very forthcoming about how this came about. They did polling and they found, well, gender affirming care bans for youth and banning trans girls from youth sports, those are polling really well and better than bathroom bans. So let's focus on those two. And that's where you see this exponential rise in these things. And so again, this has sort of been talked about, but there's the potential then for the court to allow the continuation of culture wars and politically based legislative efforts that are going to target, again, marginalized and underserved populations. And so the gender affirming care bans and the other trans attacks are just another representation of, an extension from that. And it's really important that, the medical, public health, and legal community help to situate this and say, look, the, police powers are broad, though they might be broad, they don't allow states to harm specific populations with no benefit to anyone at all, right? And that's something that really the gender affirming care ban, because it's so extreme, certainly falls into that category.
Thank you so much, Michael. And you're really painting a vivid picture of sort of the political landscape influencing which controversies get before the court rather than actual individual disputes happening, right? How we get advisory opinions and how we get the types of scenarios that we've been seeing. So wanted to see if any other panelists wanted to comment on what Michael just raised. Well, thank you. Well, what I'd like to do is bring in a couple of questions from the audience. And we have our first question here that's come in. So historically, religion was used to justify discrimination based on race and on gender. Are the modern laws against race and gender discrimination now at risk? Who wants to start? Linda.
I think that's a great question, and it's one that has come up you know, when Obergefell was litigated, it came up when Masterpiece Cake Shop was litigated, because arguments in defense of Colorado's law pointed out historically that there were religious-based objections to integration and to interracial marriage. And the NAACP Legal Defense and Education Fund even drew an analogy between three people walking into a restaurant in the 1960s and being turned away because of their race, and Craig and Mullins and the mother walking into Philip's Cake Shop and being turned away because of sexual orientation. So on the one hand, people really push this analogy to show about the similarity and continuity of objections, you know, religiously based objections, be it race, sex, or sexual orientation. On the other side, when Justice Kennedy said in Obergefell that people who oppose same-sex marriage have decent and honorable beliefs, and that we're not disparaging their beliefs, that sort of supported this notion that, you know, we can draw a sharp moral line between religiously motivated racism and religiously motivated homophobia. And you see that in 303, where Justice Sotomayor, I'm sorry, not Justice Sotomayor, Justice Jackson had these really memorable hypotheticals about what about a photographer whose business is scenes with Santa, like 1940s nostalgic scenes with Santa, but for them to be truly faithful to the world of It's a Wonderful Life, this famous movie with Jimmy Stewart, you can only have white children with Santa. And she repeatedly pushed this question. And finally, one of the conservative justices said, didn't Justice Kennedy say that people who oppose same-sex marriage have decent and honorable beliefs? And do you think he'd say that about racism? So there's this move to kind of say to cabinet and say, that's odious, that's the past, that's not where we are now. And yet at the time, people who espouse these racist views, I'm sorry, these religiously motivated views about racial segregation, thought they were sincere. And you know, in Congress, when they debated the Civil Rights Act of 1964, some religious figures came in and argued for the act, but testimony was read into the record by other religious figures opposing the act. So we shouldn't act like that's just totally different than what we've got here. You know, but the issue comes up. But as to whether these laws are at risk, I think Robert and Sean and Michael and you, Victoria, may have some views about this. Is the political will really there to roll back, you know, well, there's the affirmative action case, to literally roll back formal equality when it comes to goods and services? Everyone, I think, thinks, oh, no, we're not going to go there. But there's no limiting principle in Justice Gorsuch's opinion, honestly.
Thanks, Linda. Sean?
Yeah, and I would even go further than that, Linda. I would say that, you know, and Justice Sotomayor did a good job of this. Pointing out the ignoring of precedent in Justice Gorsuch's majority opinion. You know, it continues a trend that we're seeing with this current court, where precedent really doesn't have that much sway on what they're deciding or how they're deciding it. So, you know, in another time, another place, I might have said, well, you know, this is a bit of a backslide, but at this point, I'm not as hopeful as I would have been.
Thanks, Sean. Michael?
Yeah, so I have 2 points. You know, one of them that I want to is, even in this case, right? Sotomayor obviously brings this up, and Gorsuch does this really brief kind of, you know, to indicate that this is similar to separate but equal, you know, is just completely ridiculous. But that is, I think, clearly what's happening, right? Because if Colorado said, gay people can't go anywhere, right? I think the court would say, well, that's a problem, right? So then inherently what you're saying here is, well, you don't have to, you know, you can't get services from this woman, but you can get them somewhere else, right? And this did come up around the Civil Rights Act, you know? Again, well, I'm not gonna make a wedding website, but I might do other things for gay people, right? I'm not gonna make them a wedding cake, but I might do other things. Well, it's the same thing. Ollie's Barbecue said, I will give my barbecue to Black customers. I just don't want them sitting inside, and I want to give it to them out of a back window. And part of both the motivation for the legislation, the way that the court looked at this, was that is harmful, right? These are dignitary harms. Just by saying you're different, you can be excluded, right? That harms people, even if they're not being directly impacted. And we have this data for LGBTQ plus people, right? Where even if they have not been specifically personally denied service or care or something along those lines, the state passing laws that allows people to do that can have deleterious effects on their mental health. The other one thing that I'll add that oddly enough might sort of help, at least in this circumstance, with distinguishing. So before I thought, part of the issue here is I don't know how you can say we accept your religious stance that you don't want to serve gay people, but we don't accept your religious stance that you don't want to serve people based on their race, without running afoul of the Establishment Clause, right? And the court sort of saying, we accept and endorse and these religious beliefs, but not these others. But after recent cases, the Establishment Clause, it's really questionable whether it exists at all after the elimination of the Lemon Test.
And connecting what you just mentioned about mental health, just wanted to highlight that for a minute, to connect that with what Linda said when she mentioned the affirmative action cases. I mean, there are students right now, high school students, that are grappling with their identity and grappling with how to represent themselves in their college essays and their college applications, because of this, the way the Supreme Court has sort of cabined their ability to, or rather the university's abilities to take into account aspects of their identity that they maybe wouldn't have presented in a certain way had they been able to sort of have that information on the application shown to the schools. Right now it's hidden, so the applications still collect race data, but it's hidden from the schools. They can't see it, or they can't engage with it when they're doing the admissions process. They can only engage with it later. And this is a really tough thing and so it's almost like you're putting the burden on the marginalized or challenged class to figure out how to implement the law when really they're the supposedly the population you're trying to protect. So it's this weird backwards. So for example, like you just said, Michael, you can find someone else to build your wedding website. So now there's a burden on them to go find another, good wedding website builder, a good cake maker, or whatever it is, on the person who is being discriminated against, and they feel that while they're trying to go find a new vendor. You're absolutely right, Robert.
I guess what I would add is this. I don't think that revisiting the constitutionality of civil rights laws as it relates to race and sex are the priorities of the justices. And so, yeah, I don't really detect any real desire to do that. But so, but as we've been discussing, they're clearly treating these laws that extend the notion of equality to sexual minorities different. And why that's the case, I think is important to just understand. We've got several things going on. I mean, one is that the equality jurisprudence as it relates to sexual minorities is halting. That which exists and is protective is halting and incomplete. It wasn't that long ago, right, that the court said that if you're gay, you're entirely outside of the Constitution. No constitutional privacy rights to engage in the exact same kind of intimate behavior as opposite sex couples. And the decisions so far that have extended notion of equality when it protecting them against certain extreme political disabilities in the Romer case and Obergefell and so forth, they're important, but they're also, you could see them as limited in their scope. Deep controversy and contest beyond those areas, beyond notions of sexual orientation, to whether transgender people should be protected at all and recognized in that jurisprudence. So again, you've got jurisprudence that's halting and incomplete, unlikely to be extended with the existing court in the near future. And just back to something Michael said, if anything, I would be trying to prevent every single case from getting up there because they're likely to make bad law for the entire country and jurisprudence that's bad and terrible than litigation that's purely in the state courts where you can build on. So that's one piece of this. The second piece of this is all of the protections that have been extended, or many of them, into the marketplace and other areas have taken place at the local level and at the state level through lots of important political work by average people. But it's very clear that the court at this moment, because of the halting jurisprudence and also the absence of a federal law that clearly protects sexual minorities, is doing something different. They're not willing to carve out huge exceptions on the basis of speech or conscience or religious exercise for laws that involve race and sex, but they are opening the door wider for individuals and groups when they have these objections, such as in this case, right? We've been talking about. And I do think it has something to do with that, the comparative state of the jurisprudence and the absence of a clear federal policy in this area. So that's kind of where we are at the moment. It brings to mind something that shows up in the dissent, which is, Justice Sotomayor talks about the risk of kind of second-class status for sexual minorities, despite these protections in these local and state places. So I do think that that's kind of why it is that we're in this sort of darker gray area at the moment.
Yeah, federalism is both a feature of the system and a bug, depending on how you look at it and depending on what the context is, and that a lot of the action is happening at the state level. You're absolutely right. That's going to be the place that we need to watch and try to maybe stay away from the Supreme Court if we can avoid it. Michael.
Yeah, I just want to add briefly, we're talking about websites and cakes and things like that. And obviously they all have an impact when you allow discrimination to happen. But I will say, even before this case, if we're talking about race and sex, plenty of states had exemptions in healthcare, right, where you were allowed to say, I don't want to provide these types of services. And it just so happens that a lot of them happen to impact women as opposed to men, right? Whether they be providing abortion or contraception or STD prevention or care, right? And we're starting to see things like challenges to PrEP, right? Which influences or impacts like Black men, in the South predominantly, right, or disproportionately. So there already are these sort of laws in place that allow people to kind of exempt themselves out or deny services, especially in the healthcare space, that do have implications based on, at the very least, sex.
Very important to note that even in the current environment where we as a nation want to have equality even of gender, we're not able to fully have effect to that, particularly in the medical context. And often the insurance companies argue it's about cost, which is kind of a red herring in my view. Thank you so much. This is a great discussion. I want to bring in our next question here from our audience. And thanks so much for your questions. Great questions from the audience here. The 303 creative case lays ground for First Amendment rights to override anti-discrimination laws. Although the cases so far have dealt with whether individuals can deny selling goods and services to certain groups depending on their beliefs, do you think that this could escalate into allowing hate speech to override anti-discrimination laws also based on the First Amendment? Who wants to start? Robert.
It's hard to answer this question in the abstract. I would simply say this, that it depends on the circumstances. As we know from the court's First Amendment jurisprudence, this is something Professor McClain had mentioned, but the court has moved in a very absolutist direction, that is to say, to protect lots of things, including things that are incredibly inflammatory, racist, sexist, up until the point that you're really exhorting someone to engage in lawlessness and it's imminent. So from that perspective, it would mean that, yes, people could, under certain circumstances, especially, so let's say in a public context and in a public protest, say incredibly hateful things, and these are usually the fact patterns, right? And if the city tried to impose some kind of, or enforce some kind of equality law in that context, then yes, absolutely. The court would easily say that you cannot enforce those kinds of laws in that context. Now, change the facts a little, and we might have a very different scenario, right? If we're talking about the inside of a classroom at a public school or something else, then you've got a lot of reasons why people shouldn't be allowed to, stand up and yell a bunch of hateful things. But it's not so much because you want to squash the ideas, but it's because there are other sort of institutional pedagogical values at stake. You want the place to be able to run rather than, be a forum for wide open debate.
Thanks, Robert. Michael?
Yeah, I just I want to echo Robert's point that it's a little bit hard to think of what hate speech is, right? Or again, who gets to decide what that is, right? And so in that sense, it's not something that hate speech as a category is not protected necessarily. I think one of the other things that's interesting is, Robert brought up an educational setting, is, we're seeing more and more debates over, some people say, this is hate speech, right? And so we either don't want our school to have it, support this speaker, bring them on, or we want to be allowed to protest, either outside or even within the event. And so then there's questions of, well, is the school then obligated to stop those people from happening? Otherwise, they are endorsing and supporting the idea that it is hate speech, right? Just because it's, let's say, in the language of 303, an unpopular opinion. And so, there are issues now happening where money, resources, time, personnel are being devoted to protecting, speakers that a lot of people at certain schools and universities don't want to hear, right? And frankly, think that much of what they have to say is racist, misogynistic, ableist, any of these categories, but that to not protect and prevent, interruptions is to sort of endorse that view as, this is wrong or hate speech that's happening here. And so there's also an interesting dynamic, I think, about, can this be used to compel government, schools, whatever, to enable speech that frankly, many people find to be offensive.
A great point. And also this question that both you and Robert raised of this, what does hate speech mean? Because people use the term, but they mean different things in different contexts. There's also like a criminal definition of what is a hate crime. And so we're sort of, just because I don't like what you say doesn't necessarily mean that's hate speech, or and this is some confusion, I think, that's also underlining all of this, that the Supreme Court hasn't yet have unraveled or figured out how to clarify. Linda.
I just wanted to mention, in Justice Thomas's concurring opinion in Obergefell, where he vehemently rejects the argument that dignitary harms are sort of somehow, that you could protect Craig and Mullins from humiliation, frustration, and embarrassment. He says that this rationale is completely foreign to our free speech jurisprudence. And he quotes the flag burning case, Texas versus Johnson, where the court held that First Amendment rendered Texas's law targeting flag burning unconstitutional. I just want to read this quote. States cannot punish protected speech because some group finds it offensive, hurtful, stigmatic, undignified or unreasonable. Quoting another case, if there's a bedrock principle underlying the First Amendment, it is that government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. So how, is hateful, racist speech simply an idea society finds offensive or disagreeable? I mean, this whole notion that the First Amendment gives robust protection to offensive speech is something we're hearing all the time. But by the way, there's all these divisive concepts laws across the country based on a Trump executive order that was revoked by Biden, where you're not allowed to teach about history or civics in a particular way, if it seems to suggest people could have implicit bias or that there could be such a thing as systemic racism. So we're extremely zealous about not regulating anything someone might say because it could be offensive, but we're eager to regulate how schools can teach because we think somehow we can't make people feel uncomfortable. We can't make people feel, guilty or something. So.
No, absolutely. And what's happening in the state of Florida right now with the critical race theory courses being removed from schools and the Stop Woke Act and all of this is this similar idea. And it'll be interesting to see what happens in other states across the nation and whether or not the federal courts weigh in as well. I think we'll pull in one more question from the audience and then we'll sort of wrap up with sort of a final thought in just the last couple minutes. So here's one more question. Some litigants have deployed the compelled speech arguments in 303 Creative to challenge a book ban law in Texas, and they're citing the case Book People Inc. versus Wong, and an anti-abortion law in Idaho, and they're citing a case Matsumoto v. Labrador. What does the panel think about the offensive use of 303 Creative, and here offensive in terms of using it as precedent, I believe, or as a persuasive authority is what I think they mean here. Offensive use of 303 Creative by litigants seeking to reject Republican laws meant to control individual speech and behavior. What do we think about that? So for a book ban law in Texas being challenged and an anti-abortion law in Idaho. Linda.
I don't know those particular cases, and maybe someone else on the panel or one of our sponsors would know, but I do know that Barnett and the whole line of compelled orthodoxy cases and this notion that you can't stamp out something just because it's offensive have been successfully deployed to challenge the divisive concepts law in Florida. A federal court enjoined the law because it was basically censoring speech just because government found it offensive. And so this Barnett, and there has been some invocation of Barnett to challenge gender affirming care bans. I mean, the notion of compelling orthodoxy can be applied across the board on lots of different political things, but maybe someone else would like to answer about the specific risks of using 303 in that way.
Michael.
Yeah, so I also don't know the specific details of those cases, but I am interested in this idea of, how do you, if at all, sort of use cases that you maybe think came to the wrong opinion? And I think one of the things that that I struggle with is, there's a difference between litigation strategy and what I am able to do having no clients that I represent and being able to write my own thoughts and ideas about this, right? And so, one of the things that it brings up for me, so I'll just talk about something that I think is similar that I know a little bit more about is, again, gender affirming care bans, where part of at least some of the litigation strategy is, well, let's treat this as a parental rights issue, right? And because there's a lot of protection for that. There's a default that parents only want to do what's best for, the kids. It's a fundamental right. It'll trigger strict scrutiny, right? All of those sort of things. And so there's a strong litigation strategy, to say that that's the right thing to do. I personally also have a problem with the idea of limiting it to only cases where the parents agree and give consent. I also have a problem with the idea of, sort of hiding the transgender individual to, sort of say, look, let's not worry about, those people. Let's just talk about parents should be able to, control the medical care of their children, right? And I think that it's also part of it is thinking about not just the case that's in front of you, but what this could potentially do down a longer path, right? So for the 303 creative and these other cases, does it help you win those cases? Maybe, maybe not. Again, I don't know the specifics, but are there potential problems down the line that it could create as well by using it, right? And so again, one of the things that I tend to work on and think about and use is Roe v. Wade, right? Which said this is about privacy, this is about physician-patient relationship, right? And so, and there's the fetus that the state has, an interest in the potential life of the fetus. And so, to my mind, you can draw a path from that, right? From not focusing on the pregnant person and their body and their autonomy and their ability to make a decision, right? Because you could see a Roe v. Wade decision that comes out with the same conclusion that says, there's a person who has constitutional rights, the fetus doesn't, end of story, right? There's our conclusion. But because you didn't do that, right, there is a through line then that gets to Dobbs, where is there a constitutional right to abortion? No, not historically based. But there is this interest in the fetus, and we need to regulate medical practice and things like that. And so I think those are the risks that I worry about. But again, it's a lot easier to do when I'm not representing specific clients in litigation.
Yeah, it goes back to that question of whose rights are we trying to protect? And it depends on what the court thinks, how they frame the issue. Robert.
Yeah, I'm not crazy about this strategy. We started out and I suggested that the compelled speech doctrine has changed so much that much of it is incoherent, or at least we've gone into a place where the original justification seemed pretty different from where we are today. But that doesn't mean that we should continue to make it a bigger mess than it is. And in order to really apply the compelled speech doctrine in these situations, you basically have to say something like an individual's right to elect to have an abortion is somehow expressive, and so or that the enforcement of the anti-abortion law is forcing me to say something about myself, or the rendering certain books unavailable is forcing me to say something. See, I think these are very, very uncomfortable fits, and you really start to have, you're falling down that same slippery slope that Justice Gorsuch has started to go down, which is you're basically saying there's some conscience-based objection or opposition to the existence of a law, and I'm just going to call it a compulsion of speech in some way. To me, you're basically starting to destroy the original idea of these cases.
Good point. Sean.
And I would just
the last word.
Oh, thank you. And I would just caution people about putting too much hope into the courts. There's some great moments where rights have been protected in courts, and now we're seeing some great moments where they're not. I think a lot more attention has to be played to the state legislatures where these battles are being played out every day. And it may not seem terribly hopeful in a lot of the states that are out there, but you have just last year a huge debate about trans rights in Montana. One of the state reps was actually expelled from the House for her advocacy, but she put up the good fight, and I think that's what's needed.
Thanks, John, for that, ending us on that hopeful note. Everyone can do something, and there's still opportunities out there, lots of opportunities out there, particularly for young people, for all the students out there in the audience, to move us forward. This is the beginning of the conversation, not the end. SCOTUS is not the only place action is happening. So definitely find out where you can get involved at your local level. And we will continue to push forward. I want to say thank you to all of our panelists. Really appreciate your robust discussion and you lending your expertise today. Thank you to the BU Law School for hosting the event and the LGBTQIA+ Center for Faculty and Staff. And we really appreciate our audience. So thank you to all of you for being with us and for your excellent questions. Have a wonderful evening and take good care, everybody. Thanks.